together for a will to be deemed as properly constituted. One question that we get asked a lot is that, at what age can I prepare a will? Per our Ghanaian laws, which is the Wills Act, any person from the age of 18 years and above can prepare a will. So once you are an adult, you turn 18, you can prepare a will. And if you are 18 and above and you are of sound mind, like we mentioned earlier on, you can prepare a will. Another very important question that we get asked a lot is that, do I need a lawyer to be able to prepare a will? The simple answer is no. You don't necessarily need a lawyer. However, legal guardians is crucial to ensure that the will meets the proper requirements and reflects the true intentions of the testator. What a lawyer does is that lawyers help to ensure compliance with the law. Lawyers help to make sure that the will is properly executed, attestation is properly done, that there are no technical errors that could render the will invalid. And so although a testator or anybody has the valid right to prepare their own will without a lawyer, we recommend legal guardians to be able to ensure that your will is properly constituted. What can I put in a will? This is a very important question, and I get asked this question too a lot of times. One thing that I always say is that once you start acquiring property, no matter how small, prepare a will. The will properties can be divided into two parts. We have the movable property and then the immovable property. Movable properties such as cars, money, furniture, jewelry, shoes, wigs, anything at all that you own that is of value to you can be put in a will. You can leave it to your loved ones. Under immovable property, we have lands and houses which form the immovable property, meaning that it cannot be moved. So those ones can also form parts. You can put that in a will as well. I want to stress that there's a principle in law that is known as the nemo dat principle, which means that you cannot give what you do not have. So as much as possible, before you decide to put any property in a will, kindly ensure that the property belongs to you. You cannot go and borrow somebody's property and then come and put it in a will and say that you are giving it to someone. Before you will the house that you are giving to your loved ones to somebody, please ensure that that house is in your name, that land is in your name, that you bought it properly. It is not a laboro from anybody. You bought it yourself. The wigs as well, you bought them yourselves. Just ensure that the property belongs to you, and then you are free to will it to anybody that you want. Another thing too that can be put in a will are the executors. We appoint executors, people who will ensure that the properties that you are giving to your loved ones go to the people that have been specified to be given to. So those are the executors. That's their responsibility or their job. And then a guardian can also be put in a will. The guardians are mainly for minors. So if you have a child who is a minor being anybody below the age of from 17 and below, you can state who you expect to take care of that child after you are no more. And then another thing as well is that your funeral wishes can be put in a will. We recently had a client who had a will drafted, and his will was in two parts. He had the pre-burial will and then the post-burial will. Well, I'll not say pre-burial will because it was all one will, but it was in two sections. One part to be opened before his burial, and then another part to be opened, after his burial. His pre-burial part of the will included where he was to be buried, how he was to be buried, the time frame within which he was to be buried after his death. You can put all of that in your will. And then his post-burial will section involved the properties and what was to be divulged to each person, the distribution and everything. So you are also at liberty to do all of those things. Your will can include your final wishes. Your will can include your movable and immovable properties. Your will can include people who you expect to take care of your children after you are no more. Now we come to updating your will. It is important to mention that a will can be revised at any time. You can add to your will, you can take out of your will, you can add people, you can add properties, you can take out people, you can take out properties. You are at liberty to do that as well. For minor changes, which is changes such as you want to add somebody to your will, you want to readjust specific gifts to certain people, we have a document called the Codicil. The Codicil is attached to the main will, and that usually has the minor changes. However, if you want to make a major change to your will, what we advise is that you prepare a completely different will or a new will. And in doing so, you will need to revocate the old will. What we mean by that is that in the new will that you are preparing, there's a clause that we put in there that says that I am revoking the old will that has been done. And so that ensures that there's no disputes or no misunderstandings or ambiguities concerning which is the new will and which is the old will. How do we know that a will is the final will? In our earlier slide, we spoke about the revocation of wills. I would also want to touch on the fact that aside from revoking the old will, there are other ways as well that a will can be revoked. When you burn your will, or you tear or you destroy your will with the clear intention to destroy it, it means that you have revoked that will. If you give permission to somebody to tear, burn, or destroy the will in your presence, it means that that will has been revoked, which also means that then that will is no longer in effect. And so when we are looking at the revocation of wills, we need to be very careful, because revocation of wills has been something that has caused a lot of disputes and issues between families. Once you decide that you are making a new will, ensure that your old will is properly revoked. Either it is destroyed or you state clearly in your new will that you have revoked the old will. One way that we lawyers do that is that we put in the new will a clause that says, I hereby revoke the former will and testament dispositions made by me, blah, blah, blah. And so then that clearly states that the will has been revoked. I also want to stress on registration of wills. Do I need to register a will? A will does not need to be registered. It's not mandatory for a will to be registered. However, it is advised that a copy of the will is deposited at the High Court. By doing so, it provides certainty that the will is safe, it is authentic, and can easily be located after the person's death. It means that if the executor goes to the courts, they can get a copy of the will, which they are sure is authentic, and it's the new will and they can get a copy of the will, and then the will can be drafted. It also ensures that once you deposit the will at the court, it ensures it prevents disputes about missing wills and tampered wills and all of that. So although you don't need to register a will, we will recommend that a copy of the will is deposited at the High Court. Let's briefly touch on whether or not a court can amend my will. The simple answer to this question is yes. A court has the power to amend a will. The court does not find delight in amending wills because it respects the testator's wishes in whoever they want to will their properties to. However, the court may step in exceptional circumstances. Circumstances such as where a dependent is left without adequate provision. So under Section 13 of the Wills Act, if a court is satisfied that the testator has failed to make reasonable provision for the maintenance of a spouse, a child, or a parent, or a dependent, it may order that provision be made for them from the estate. This section safeguards or acts as a safeguard to ensure that there is fair and just allocation of properties to dependents. Where the court feels that a dependent has been left destitute, the court may step in and apportion or give some properties or make provision for that dependent out of the will. A clear case of this can be found in the case of Ekwuamarfor versus Margaret Akosia Ejiowa. In that case, a testator or a man died and he had multiple wives and decided to leave one of his wives out of his will. The wife appealed, or the wife brought a suit before the court saying that she was a dependent of the testator. She doesn't have any means to take care of herself. She doesn't have anywhere to live. She doesn't have any money. And so by the testator leaving her out of the will, it is going to cause her great hardship. What the court decided, it went all the way to the Supreme Court. What the Supreme Court decided was that the Supreme Court gave a portion of the house that they were living in as a family house to the woman to live in during her lifetime, which meant that when she died, the house no longer belonged to her, or the room she was living in no longer belonged to her. And then they also gave her a portion of a farm where she can farm on to get money to take care of herself. So you can clearly see that the court is interested in the welfare of your dependents. The court is interested in the welfare of your children, your spouse, your parents, and basically your dependents. And so if for some reason you decide to leave your dependents out of your will, the court may step in and make sure that they are covered. There are a lot of misconceptions about wills. And I've heard in my line of work, I've heard very dumbfounding reasons why people do not want to make a will. I remember some time ago, after I finished law school, I gathered my family together, trying to show my crashy powers a little. And I asked my parents, and in fact, I didn't ask them, I demanded that they make a will. My father was quite accommodating, he understood. But then my mother goes, hey, Dabi, small magbo, to wait. Hey, no, I do not want to die. And that is the of the major misconceptions that people have about wills. It's a superstition that has caused a lot of problems in families because people do not want to make a will and then they die. Preparing a will does not mean that you are going to die. Preparing a will is an act of love or an act of responsibility that you show to your loved ones or to your family. Because what it does is that it prevents disputes. A lot of families, like we mentioned before, a lot of families are torn apart because a person decides that they do not want to make a will for whatever reason. But once you prepare a will and you clearly state that I want to leave this property to this person and everybody understands, it means that some family disputes are avoided. And so, please, preparing a will or making a will does not mean that you are going to die. Another misconception that people have about a will is that the will is only for rich people. It is very false. A will is not only for rich people. Like I mentioned before, as soon as you start acquiring property, no matter how small, prepare a will. It could be a shoe that you are very attached to, that is of sentimental value to you, and you want to leave to somebody. It could be books. It could be a bicycle. You could even have 500 cedis in your account, but you want to ensure that that money or those properties go to the people that you want them to go to. And so the best way to do that is to make sure that it is written or it is prepared in a will. Wealth is not a requirement for preparing a will. Another misconception about wills is that customary law will take care of it, or what I like to call my busuapeni will share my property. This is another huge problem that we have encountered so many times. Shakespeare said that there's no art to find the mind's construction in the face, meaning that you do not know the intentions or the mind of anybody. Even the Bible says that the heart of man is desperately wicked. You could trust your busuapeni to share your property or a close friend of yours to share your property. But people get greedy. People can become dishonest. They are all human traits. You do not know what they want to do in future. To ensure that your wishes are properly carried out, your safest bet is to put it in a will. Your will is your safe bet. Your will cannot be manipulated by anybody. Your will states clearly what goes to who. And so please ensure that you prepare your will. Another misconception that people have is that my spouse and my children will automatically inherit everything. That, unfortunately, is not true. Your spouse and your children will not automatically inherit all your property after you are dead. Under PNDC Law 111, your properties are divided after your death. If you do not leave a will, if you die intestate, your properties are divided between your spouse, your children, your parents, and then your customary successor, which means your extended family, your nieces, your nephews. Those form part of your customary successors. So let us break down PNDC Law 111. The first stage is that certain assets of yours, which is your house, the car, the house that you live in, which is your matrimonial house, and your car that you use, is set aside for your surviving spouse and the children. They do not form part of the residue that is to be divided. Your household chattels, such as your furniture, appliances, clothing, and non-commercial vehicles, are set aside for your surviving spouse and your children. And then if you have one house, that house is also set aside for your spouse, your surviving spouse, and your children. However, if you have multiple houses, your wife and your children keep one house, and then the rest of the houses form part of the residue of your properties, and they are shared between your spouse, your children, your parents, and then your customary successor. This is done in this format. 3/16 goes to your spouse or spouses. That is if you have multiple wives or you have multiple husbands. 3/16 of that property goes to your spouses. 9/16 goes to your children, no matter the number. If you have 19 children, if you have 10 children, if you have 2 children, 9/16 of it goes to your children. And then your parents get 2/16, and then the customary family or the extended family gets 2/16. So for instance, if you have 160,000 Ghana cedis as the total of your estate, your wife or wives gets 30,000 Ghana cedis. Your children, no matter the number, collectively gets 90,000. Your parents get 20,000. And then the customary family or the extended family gets 20,000. The issue with PNDC Law 111 is that, number one, the distribution is rigid. As I have mentioned, it is the law does not deviate. The percentages or the fractions are set. They do not change. And so it gives, you can imagine if there are 10 children and they all have to share 90,000 Ghana cedis. And if they are young, it goes all the way up to their adulthood, the schools that they are going to go to, taking care of their day-to-day needs. It becomes a challenge. Your parents as well, they may need more than the 20,000 cedis that the law is giving them. And that also becomes a challenge. And you may or may not even want to give your extended family or your customary successors anything, but then the law makes provision for them under PNDC Law 111. Another thing that we need to take note of as well is that PNDC Law 111 does not recognize long-term or unmarried partners, which means that if you are living with someone and you've been together for 20 years and you are not legally married, once you die and you do not prepare and you do not have a will, those partners do not get anything under PNDC Law 111. If you have children with this person, that person does not get anything. Your children will get something, but then the person that has been with you for all those number of years will not get anything. And so that I've realized that comes with a lot of difficulty because most people cohabit. Most people do not marry legally, and they live together for so long, and then their partners die, and then under PNDC Law 111, they are not inheriting, and it becomes a problem. And so to ensure that you do not have to deal with all of those things, well, of course, you don't have to deal with it because most likely you will not be here, but to ensure that your loved ones are properly covered, are properly taken care of, please ensure that your wishes are clearly stated in a will. And so with all that has been said above, I think that we can clearly see that it is important for every adult, once you start acquiring property, to have a will. What does a will do? It prevents family disputes. It reflects your true intentions. It protects your dependents. It protects your loved ones. It makes the probate process simple because you do not have people running about claiming properties that do not belong to them. And then it avoids customary law conflict. And so it is important. I do not know how to stress the importance of a will. A will is crucial in ensuring that your loved ones are taken care of. I want us to just briefly reflect on last year's very painful death of Herbert Wigwe. For those who do not know him, he was the CEO of Access Bank. He and his wife and his son tragically died in a helicopter crash, leaving their daughter. And Herbert Wigwe prepared a will and left everything for his daughter. After the will was read, a couple of months, we saw all over the news that Herbert Wigwe's father, a 90-something-year-old man, had sent his daughter to court, claiming that their daughter does not have the capacity to take care of the vast properties that has been willed her, and so he should be named as the rightful executor of the properties. The matter was taken to court, and the court ruled that the wishes of Herbert Wigwe, as was clearly stated in his will, should be respected. This is what a will does for you. A will ensures that when people who want to come and distort your wishes, try to, for lack of a better word, cheat your family out of what is rightfully theirs, your will speaks for you even beyond the grave. Your will ensures that your loved ones are properly cared for, your loved ones are properly protected. And so if you've not heard anything throughout the 30 minutes that I have been speaking on wills, please remember that preparing a will is an act of love that you can leave for your loved one. Now, let us just briefly talk about trust. One aspect of asset distribution or management that most Ghanaians have not averted their minds to is the creation of trust. What is a trust? A trust is a legal arrangement where a settlor gives assets to a trustee to manage for a beneficiary. Now, let's break this down. Who is a settlor? A settlor is the person who sets up the trust. Is the person who gives the property or the trust property to a trustee. Who is a trustee? A trustee is a person or an institution appointed by the settlor to manage or administer the trust property in accordance with the terms of the trust. Trustees have a legal duty to act honestly, prudently, and in the best interest of the beneficiaries. Who are the beneficiaries? The beneficiaries are persons or a person who benefits from the trust. They can be anybody, your children, your spouse, your parents, a charitable institution. They can be beneficiaries of a trust. And then what is a trust property? The trust property is the asset that has been placed in a trust by the settlor. A trust property can include money, land, shares, investments, or any valuable property that can be held by the trustee for the benefit of the beneficiary. Now, there are many types of trusts, but for the sake of this webinar, we would like to discuss three main types of trusts. The first type of trust I want to talk about is the living trust, also known as the inter vivos trust. The living trust is a trust that is created by the settlor during his lifetime or during their lifetime. The assets are transferred from the trust while the settlor is still alive, allowing for easier management and distribution of the property. The second type of trust that I want to talk about is the testamentary trust. A testamentary trust is created through a person's will and only takes effect after a settlor's death. It is commonly used to manage or protect assets for minors or dependents over a time rather than giving them a lump sum of money. And then the third type of trust that we want to talk about is the charitable trust. A charitable trust is established for public or charitable purposes, such as for education, for healthcare, for poverty relief. People can set up trust for whole in heart patients or a community development. Something that is charitable or that gives to other people is known as a charitable trust. So it is a trust basically that benefits the public rather than specific individuals. One thing that we want to also discuss is that for a trust to, for somebody to be able to set up a trust, the first thing is the intention of the trust. People set up trusts for various reasons, to provide for their children and their dependents. It's a form of wealth creation. It's a form of succession planning. Like we mentioned above, it is also a charitable, a means of giving back to the society. A trust involves three main parties, as we mentioned: the settlor, the trustee, and then the beneficiary. In choosing a trustee, you have to make sure that the person or the institution that you are choosing as a trustee is somebody that is reliable, that is legally competent, that has that can take care of financial responsibility. So for instance, nowadays there are companies or there are institutions that serve as professional trustees. You can have your lawyer also as a trustee, and they make sure that the trust is properly administered. The trust property is also one thing that is also very important in creating a trust. A trust property needs to be able to be easily identified. So if it is cash that you want to leave, or you want to set up some kind of investment with that money for your dependents in the future, you can set that up. It needs to be money that is set aside. Lands or buildings can be set aside. Shares or securities can also be set aside. This is how a trust works. So the trustee gives the settlor gives the trust property to the trustee in a document known as the trust deed or the deed of trust. The deed of trust sets the terms and the conditions under which the trust should be managed. And so the deed of trust can state the dates that the trust should be set, the age the beneficiaries can now come into their trust or can now benefit the trust. And then the trust deed basically just sets the terms and the conditions for the trust. An important thing that we also need to note is that for trust properties such as land, once the trust is set up, the trust needs to be registered at the Lands Commission. So if you have a land that has been put in a trust, or property or a house that is put in a trust, that land or that house needs to be registered at the Lands Commission. So we can say that proceeds of the house, or the house should be rented, and the proceeds or profits from the renting of the house should go to taking care of your children or your dependents from the time they are young till they are up to maybe 25 years, when they can now come into their trust. all of those terms and conditions are set in the trust instrument. And so we need to, we need to avert our minds to the use of trust. Trust help in wealth creation. Trust help in wealth creation. What trust do again is that trust
in progress.
Sorry, thank you very much. We had a little technical difficulty, but we are back. Thank you for your patience. What trusts do, again, is that trusts ensure that your dependents, your children, your spouse are covered in future. And so it sets their future, it sets a set amount of money or property aside for them to ensure that their future is covered. Why create a trust? One reason why a trust is important, or why we should create a trust, is that a trust protects vulnerable dependents. A trust ensures that loved ones who are too young or elderly or unable to manage money are cared for responsibly. So, example, a parent with a child who has special needs can set up a trust so that the funds are managed by a trustee for the child's long-term care, preventing misuse or exploitation. Another advantage of a trust is that a trust is used to manage generational wealth. A trust helps preserve and grow family assets across generations by setting clear rules on how wealth is used or reinvested. So, for example, a grandparent may create a trust or a family trust to fund their grandchildren's education, or a business starts up whilst keeping the core investment intact for future generations. Another advantage of a trust is that a trust helps in avoiding family disputes by clearly outlining who benefits, when and how they benefit. A trust reduces confusion and conflicts after a settlor's death. Example is, instead of siblings fighting over property, the trust specifies that rent from the family house goes into a joint account and it is shared equally among the beneficiaries. A trust also provides flexibility. Unlike a will, a trust can take effect during the settlor's lifetime and can be adjusted as circumstances change. So, for example, a settlor can replace a trustee, can add beneficiaries, can change how income is distributed, amongst the beneficiaries, etc. Now, for the all-important question, which is better, a will or a trust? The simple answer to this is neither. You can set up a will, or you can set up a trust, or you can set up both. As we learned above, a trust you can make provision for a trust in a will. So you look at your circumstances, you look at your family, the needs of your family, and decide if a will is best suited for your family or your dependents, or a trust is best suited for your children your spouse, or your dependents. It all depends on you. You can do whichever one you want, or you can do both. Finally, we want to say that it is highly important for you to take charge of your legacy. In recent times, we have heard how families are being torn apart, how families are going to court because there aren't clear guidelines or rules or clear distribution of properties among family members or among loved ones. Your will or your trust does that for you. A will is an act of love. You ensure that your loved ones are properly cared for. You ensure that your loved ones are not thrown into any disputes that is going to cause hardship to them in the future. And so to conclude, we want to say, create a will and do so now before it's too late. Thank you, and we welcome questions.
Thank you so much, Lucille. Thank you. It was so insightful. At some point, I felt I was in the Ghana School of Law. Like I actually felt, because I've learned a lot. And Lucille, I agree with your mother. I also had that misconception about wills, because I believe that it is when you are going to die that you prepare a will. And also it is only rich people who also who prepare a will. But today you have actually explain things better for us to understand that even me here, I'm above 18 years. I was thinking that it is when you get to maybe 60 years and above, or let's say 50, that you start preparing your will and all that. And when you have maybe properties. But now I understand clearly. Thank you so much. And one thing I also learned is that a will can be in writing and must be signed by a testator. And you also said that you don't need a lawyer, but you only need a legal guidance. I didn't know this. Thank you so much. Please, I encourage everybody to put in your answers and we will answer your questions for you. So we have some few questions that people need answers to. So the first one is a handwritten will valid in Ghana? Is a handwritten will valid in Ghana? So Lucille, kindly help us with the answer.
So yes, a handwritten will is valid in Ghana. The most important thing is that it needs to be signed. Once it is signed, it is valid. Once it is in the presence of two witnesses, it is valid. Once the person who wrote the will on a sheet of paper is of clear mind and of sound mind, the will is valid. So yes, a handwritten will is valid.
Okay, thank you so much, Lucille. And the second question is, if I have a property in UK and Ghana, do I need two different wills? If I have properties in both UK and Ghana, do I need two different wills?
Well, you do not need two different wills, but we recommend that you make two different wills. The thing is that it's a jurisdictional issue. And so the UK property is governed by different laws, different set of laws than the Ghana property. If you are setting up one will, it means that then the executors in the UK will have to now come down to Ghana and now come and, apply for probate and all of that. It becomes a bit cumbersome. So just to make life simple for everybody, we recommend that you prepare one will for your properties in the UK, where you can now make provision, your executors are stated in there, and then you make another will for your Ghana properties with executors in Ghana, so that when you are no more, the probate process becomes simple for each of the jurisdictions.
Thank you so much, Lucille. So please, the next question, the person is asking that, do I need witnesses if I'm thumbprinting my will? Do I need witnesses if I'm thumbprinting my will?
Yes, absolutely. If you are thumbprinting your will, that is even when you even need witnesses the more, because we need to ascertain that it is indeed you who stamped or who thumbprinted the document. And so it is crucial that you need witnesses. And in fact, there's also an attestation clause in documents that are thumbprinted. So an attestation clause says the person creating the will or the testator, the contents of the will have been read to this person. The person understands what he or she has put in there before they now thumbprint. And these need witnesses to be able to make sure that their will is valid. So yes, you need witnesses.
All right, thank you. And I think in your session, you made mention of having two witnesses, and somebody is asking that, must the witnesses be privy to the full contents of the will?
No, the witnesses might not be privy to the full contents of the will. They just have to ensure that they just have to witness the fact that you are the one who is signing the will. They do not need to know what goes into the will. No.
Okay, all right, thank you. So the last two questions, someone is asking that, when is the appropriate time for reading a will? Must it be done before or after the funeral rites? Must it be done before or after the funeral rites?
Okay, so here it is the testator that determines. Like I mentioned in my submission, you can have two parts of a will. You can have the pre-burial will and then the post-burial will. So that depends on you. The pre-burial will usually contains your funeral wishes or how you want your funeral to be conducted. And then the post-burial will is what now distributes properties among your beneficiaries. So it depends. The testator is the one who has absolute right to determine how or when the will is read. But most people do it after the funeral, just so there's some kind of harmony during the funeral. Sometimes reading a will can cause tempers to flare up and things like that, especially when people feel that they should have been given certain properties that they were not given and all of that. So some people feel that reading the will after the funeral is the best. It's not a hard and fast rule. The testator determines when and how the will is read.
Thank you so much. The next question is, can the family go against the wishes of the testator with regards to funeral wishes about cremation because the dead body belongs to the family? Can the family go against the wishes of the testator with regards to funeral wishes about cremation because the dead body belongs to the family?
Yes, the dead body does belong to the family, and the family can determine how they want the body to be buried. But as much as possible, we want to respect the wishes of the dead. So it is, again, it's not a hard and fast rule. The body does belong to the family. The family determines how the burial is done, or how the burial is done. And so if they go against the wishes of the testator, it's up to them. As much as possible, they should try and ensure that the wishes of the testator are respected.
Okay, thank you so much. And please, someone is asking that in this era of technology, will it be out of place for the witnesses to rely on online means?
I'm sorry, come again. I don't understand.
Sorry, in this era of technology, will it be out of place for the witnesses to rely on online means? Maybe the person is trying to say, for the witnesses, do they have to be there in person, or maybe, we have now, because of technology, the advancement of technology and all that, can it be done maybe via Zoom, that maybe Lucille will be in the US and I'll call you and ask you to join my lawyer and I whilst we prepare my will or something? Is it possible?
You need to prove that you were there. You need to prove that it was in your presence that the testator signed. And so I don't know how doing that via Zoom is going to work, but it is advised that the persons are present physically during the signing of the will. I understand that in this new technological era and all of that, maybe you would want to do e-signing or something like that. But, well, that area of law has not been tested yet. But I think that it is important for you to be physically present. So if you want a witness, there are people all around you. You can have somebody who is with you to sign, just to make sure that it is in the person's presence that you are signing, and then the person also signs.
Okay, thank you very much. Thank you so much. The questions are actually a lot, but I don't think we'll be able to answer all. But I will encourage everybody to reach out to us if you want a personal session where you want to interact with or engage with any of our legal team members. You can actually pose your questions and they will answer, but we are actually limited by time, so we would have to close. But I have two more questions that I would want Lucille to help us answer them. So one is, how long is the probate process? How long is the probate process?
The probate process, it doesn't have a fixed time or a fixed time frame. It varies. And so there isn't a fixed time frame. Some may be shorter than others, some takes longer than others. And so once the application is done to court, we try as much as possible to have it done quickly so that then the assets can be distributed appropriately. So we cannot state emphatically that it takes this set number of days or weeks. Sometimes it can take a few days, sometimes it can take a few weeks. But as much as possible, we try to ensure that it is done quickly so that the will can be read. Beneficiaries receive their properties that have been given to them in the will, and then life goes on.
Okay, thank you very, very much. And one, I think I'm very much interested in this question. The person is asking that, how do you leave a will when you have a joint property with your spouse? So let's say you are married and the man dies, and the man wills maybe the property that he built with his wife to one of his sons or daughters. How will it be? When the woman is alive, the wife is alive. Yeah.
Okay. So a joint will can be created, right? We make provision for a joint will. You can have two separate wills, but then you can also have a joint will where both of you together determine that this property is going to go to this person. But then if it's a joint property, whilst the woman is alive, the woman is the one who owns the property whilst she's alive. You understand? And so the property cannot go to somebody else. I hope it is clear. It is after both parties have died that now the property can now move to somebody else. But if one person is alive and then one person is dead, the other party or the other partner is the one who now owns the property. So it cannot be willed to somebody else.
Okay.
I hope it's clear.
Thank you so much. It's so clear. And the last question is, how many years should a testamentary trust, how many years should a testamentary trust last? Can it be extended for 3 generations? That is a question from somebody. How many years should a testamentary trust last? Can it be extended for 3 generations?
So there's a fixed, a trust is not perpetual, meaning that a trust cannot go on in perpetuity. 3 generations is a bit long. So 3 generations would, usually a trust lasts about 25 to 30 years before it would need to, the content or the modalities of the trust may change. And so 3 generations is a bit much.
Okay, thank you so much, Lucille. The questions are many, but like I said early on, please, you can reach out to us and we'll answer your questions. Somebody is asking about the legal fees that we will charge if the person doesn't have a personal lawyer to help with the drafting of the will. I'll say that reach out to Firmus. Our legal team is the best. We will help you answer all your questions. So we hope today's discussion has given you a clearer perspective on how to make informed decisions to secure your future and that of your loved ones as well. So at Firmus Advisory, we remain committed to empowering individuals with the right information to make sound legal and also financial choices. So if you have further questions, like I mentioned, please don't hesitate to reach out to us. We are ever ready to help you. Thank you so much for taking your time to be part of today's webinar, and we look forward to having you again in our future sessions. Thank you. Enjoy the rest of your day. Bye.
Bye.
Registering your business in Nigeria can be a hassle. Even though the CAC platform allows you to register your business online, however, not anybody at all can do that. First, you need a CAC accredited agent. You have to go through a whole lot of documents online to get all that done. You are worried about your business name, which type of business you should be registering. All this can be very messy, and that is where we come in with our value. Firmus Advisory, operating from Lagos, Nigeria, helps you with all your CAC matters, from choosing a business name to choosing the type of business that you should be registering, to formulating your business object, company secretarial, and all these matters. Our expert team in Lagos will help you to get all that sorted. We provide full-fledged CAC registration support for your business registration with very fast delivery and also competitive pricing. Reach out to our legal team in Lagos and we'll be happy to add value to your business and help you to grow. Registering your business in Nigeria.
When starting a company in Ghana, legal due diligence is critical to ensure compliance and to mitigate risks. Firstly, it is crucial for a foreign investor to have a contract drafted when entering into partnership with a Ghanaian. This ensures legal clarity and safeguards or protects the foreign investor. Ghana's legal systems has specific requirements and nuances that may not be familiar to the foreign parties. It is important that the contract aligns with local laws, protects the investor's interests, and clearly defines each party's rights and responsibilities. This prevents disputes, safeguards investments, and ensures compliance with Ghanaian regulations, giving the partnership a solid legal foundation for success. Corporate governance is equally important. The Companies Act, Act 992, mandates companies to have at least 2 directors, a shareholder, an auditor, and a company secretary. The shareholding structure must be clearly defined, including the rights and responsibilities of shareholders. Regular board meetings, adherence to fiduciary duties, and maintaining accurate records of resolutions are key to ensuring and running a company that is transparent and compliant. When starting a company in Ghana, legal due diligence.
Firmus Advisory Limited is a consulting firm established in 2013 based in Accra, Ghana, where we provide 3 core services. Number 1 being regulatory compliance, 2 is market research, and trade development. Our regulatory compliance division is a division where we basically take care of a company that is expanding here into Ghana. We provide core services from company formation, immigration-related services, company secretarial, as well as other key licenses that are required for every new business that is expanded into Ghana. Here at Firmus, what we've sought to do basically is to bring under one roof all the key services that you need. And really, our strength and our unique selling proposition is the fact that with us, you don't have to move from agency to agency to get your issues sorted. With us, you're able to have subject matter expert who can speak to tax, who can speak to immigration, who can speak to company registration, and will take care of your company and provide you solutions that help you have the peace of mind to work and to start your business here in Ghana.
So our research and trade development services focuses on providing insights as well as market analysis for existing companies as well as companies that are looking to invest in Ghana. For trade development, we focus on connecting markets. So if you're a Ghanaian company looking for a potential partner outside the country, we do assist in securing those partnerships. If you're a foreign company looking for a local company to partner, we do provide due diligence services, among others, and connect you to those companies. We don't only focus on foreign companies that are looking to invest in Ghana, we also focus on Ghanaian companies that are looking to expand and better understand the market. We have a host of industry experts that help you understand that.
We work for a number of brands in Ghana as well as global. We work for brands like ABSA, formerly Barclays Bank. We work for International SOS. We work for Honda, we work for Jethro, and a whole host of other firms, and we have clients in Ghana and across the globe. So we are happy to extend our services to you as well and to serve you. Our name is Firmus, which simply means reliable in Latin, and we are simply inspired to deliver value. Firmus Advisory Limited is a consulting firm